Did you know that during a pretrial question and answer session known as a deposition, I can ask the witness questions about things that he overheard somebody else say? But did you know that I might not be able to use that information at the time of trial? You want to know why not? It has to do with something called hearsay. Let me explain what I mean. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. All right, there's something called hearsay. Now, what is that? You might see it on TV during the middle of a courtroom drama. I'll tell you what it is. Let's say you're at trial, right? And now a witness is up on the witness stand. And the attorney asks the witness, hey, Mr. Jones, what did you overhear somebody on the corner say about what they saw involving the accident? The other defense lawyer jumps up out of his seat and says, objection, Judge, that's hearsay. And you know what the judge says? The judge says, Counselor, you're absolutely right. That objection is sustained, which means, Mr. Witness, you cannot answer that question. Now, what just happened there? I'll tell you what just happened. The attorney asked this witness to talk about a conversation that he overheard. He overheard at the time of this incident. This witness on the stand did not personally participate in a particular conversation with this guy who saw the accident. He was not there to personally witness the actual accident. Instead, he overheard somebody talking about the accident and what they saw. So now the attorney is trying to get this jury information about this particular person to talk about something that he overheard. Now, hearsay basically says, wait a second, how do we know that the information that's coming from this particular witness is accurate? How do we know that this information is truthful? Because this witness did not personally observe what occurred and did not personally hear exactly what occurred in this incident, how can we trust the truth and the veracity of what this witness has to say? Guess what? Now the judge says, hold up! This witness cannot tell the jury about whatever it is he overheard. So now, what do? I'll tell you what you do. You try and identify and try and locate the person who does have that information. Who was it who witnessed the incident? Who was it who participated in that conversation? Those are the people we want to bring into court to now explain to the jury what they saw and what they heard. Now the jury can then evaluate whether or not that information is believable, whether it's truthful, and whether or not it will help our particular case. But now, during the course of pretrial testimony, which occurs anytime somebody brings a lawsuit involving claims for personal injury, claims for medical malpractice, or claims for wrongful death, each side has an opportunity to learn from our witnesses exactly what this witness heard, exactly what this witness saw, and what they remembered. That's the discovery process. Whether we can actually use that information at the time of trial is a totally different story. Let's say it's a car accident case, and now we bring in a witness. He's standing on the corner. He claims that he spoke to somebody who witnessed the accident. If I were to go ahead and ask, hey, Mr. Jones, did you see the accident? No, I did not. Did you hear the accident? No, I did not. But while you're standing on the street corner with your back to the accident scene, did you speak to somebody next to you who did witness the accident? Yes, I did. Tell me what this person said to you. Now, normally if we were at trial, the other attorney would yell out, objection, that's hearsay. And it is hearsay, but I'll tell you under what circumstances we could get that information in. But during the deposition, I can now ask this particular person who's standing on the street corner with his back to the accident scene to tell me everything that he spoke to this other person about. Oh yeah, this guy told me that he just saw this accident. He saw this guy go through a red light. Oh my God, I can't believe this. That blue car went right through the red light. And you should have seen the impact. Boom, I heard everything. Okay, so now he's relaying everything that this witness told him. Under what circumstance can I now get that information into court in front of a jury? You know when? When we've had an opportunity to also question this witness who he's talking about, he had a conversation with, who did witness the incident. So if we have the ability to identify that particular individual, and now we have the ability to question him during this pretrial question and answer session known as a deposition, now we can learn directly from that witness exactly what happened. So each side will now know exactly what he saw and what he heard. So now at the time of trial, if that person moved out of state or is no longer available, now we can use the information that he testified about during his pretrial questioning. We can now use that at trial. Why? Because each side had an opportunity to inquire. Each side had an opportunity to learn what this individual knew, so that now, if he's no longer available, we can then use this other witness who spoke to him, where each side had an opportunity to question that witness as well. And in some instances, we may also be able to use the testimony in the form of a transcript to read what this witness said during his pretrial questioning. So why do I share this great information with you? I share it with you because this came up recently in a case I was handling, and I wanted to explain why it is that we are permitted to ask questions about what somebody else heard and talked about, but at trial we may not be able to use that information. You know, I recognize you likely have questions or concerns about your own matter. Well, if your matter did happen here in New York, but you have not yet started a lawsuit, but are thinking of doing so and have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.